Hey everybody, Mark Dawes here. Hope you're having a good Friday. Now, I was having a conversation yesterday with a guy who's a specialist in contract law, and we were having this discussion about what he offers. And one of the things that came out of there, which is really interesting, is there's a clause in a certain Act of Parliament that says that if you deliver goods or services that aren't fit for purpose, then your customer doesn't have to pay you. Simple. End of. So what's that got to do with us? Well, I put a post up on LinkedIn this morning about a Department of Education document or a letter sent out in May of this year. And in there, it's referring to the Guide to the Children's Homes Regulations 2015. And in there, they state that you cannot ever use a technique that causes pain with a child because it wouldn't be proportionate. Now, that's not what the actual regulations say, the statutory regulations. The statutory regulations say as long as force used is necessary and proportionate, it's fine. But now they produce this guidance which says, yeah, but if they use pain, it can never be proportionate, which is absolute nonsense. But here's the thing. We've got lots of organisations telling us what we can and can't do. And if you want certain certifications, you've got to go along with their structure and not teach certain techniques. And lots of agencies are being told, and misdirectly told, because the person advising them is not competent to do so, that you can't use certain techniques, like you can't use a pain compliance technique as the general one, because it would be abuse. Now, we've done a number of FOI requests, and we've proved that these inspectors don't get any training in this area, so therefore are not competent to give that advice and shouldn't be doing it. So it falls under HSG 48 as a rule or knowledge-based mistake. That, they're giving information that could lead to a harm occurring that wouldn't have occurred had the person been given the right information and implement the right training. But what if you, as a training provider, implement training or take out stuff that works, that is needed by an organisation, and by taking it out you create a risk? Or you deliver training and you tell them that you can't use force that could cause any amount of pain, and pain is subjective, by the way, all right? You can't measure pain, but you can't use force that causes any pain because this guidance document says so. So you omit that from the training, and now there's a gap in the training requirements, and that gap leads to people being hurt. And if you want to look at claims, there are thousands of claims every year from people who are injured at work. Violence at work is the third largest cause of injuries in the workplace, by the way. Well, if you turn up and deliver that training, or you deliver the training and it then transpires that training is not fit for purpose, they don't have to pay you. All right? They could probably sue you for the money back as well. Now, the specialist who was telling me this yesterday in our conversation, I've asked him to put a course together and put that course out there. So if you're listening to this, go and put that course together and get that course out there, because people need to know this stuff. Just signing up for a set of standards or just paying a shed load of money to get certification which isn't worth a carrot, and being dictated to about what you can and cannot do, which, if it is below the legal threshold, so you're leaving things out that could legally be put in, if that's then leading to a risk, you've got a potential problem, and your business has got a potential problem. Anyway, just me wanted to raise that point. Tony, if you're listening to this, get the course out there, mate. People need that. And speak to you soon. Any comments, leave them below the video. Take care. Have a good Friday.